Bribery. What is bribery? Bribery is the act of giving, offering or accepting, or causing to be provided, offered or accepted, a benefit, anything of value, to any person in order to improperly influence an act or decision so as to gain a business or personal benefit or advantage. So as part of the definition, what's a thing of value? A thing of value may be a financial or other advantage. It may include gifts, forgiveness of debts, loans, travel or hospitality, medical care, employment opportunities, or protection from penalties or any proceedings of a penal or disciplinary nature. Bribery can be provided directly or indirectly, that is, via a third party, and it is irrelevant whether the bribe is successful in improperly influencing another person or in securing a business advantage or personal advantage. The very key element of bribery is the intention of the person engaging in the conduct of bribery. So what's the difference between bribery and corruption? Bribery is a form of corruption, and corruption is the abuse of a position of employment, authority or trust to gain a business or personal advantage or benefit. There are many different forms of corruption. There are lots of types of corruption offences. Some of these include blackmail, fraud, perverting the course of justice, abuse of a public office offence, also some false accounting offences. There may be many you can think of too. So looking at bribery, it's helpful to think of it in terms of different types of offences can be conducted in different contexts. That is, there can be political bribery. That involves political favours, such as votes or contracts. Judicial bribery, involving the influence of a legal decision. There's bribery of public officials, involving a public servant or a public official being bribed in exchange for a favourable decision. There's also foreign bribery, and that's bribery of a foreign official in exchange for favourable decisions or advantages. There's also commercial bribery, and that involves bribery with respect to a business transaction to gain an advantage over others. Now, there are other provisions that are relevant to bribery offences too, and these are worth noting. There are corporate liability provisions, and these deal with companies that may be liable for the actions of the employees or agents. And often you'll find that these corporate provisions will be utilised with bribery offences, and there will end up being corporate accused in bribery prosecutions. Then there's also provisions for conspiracy. Conspiracy charges are very common in bribery matters because, well, bribery conduct involves more than one individual. So you'll often find conspiracy charges are involved. There's also often money laundering offences which may be charged in addition to or may be charged with respect to bribery conduct, but the bribery offence itself isn't charged. And that's because they're relying on the dealing of the proceeds of a bribery offence. So you might find money laundering comes up in bribery and corruption cases. The other thing you'll find that intersects with bribery and corruption cases is civil asset recovery proceedings, restraining orders, confiscation orders and pecuniary penalty orders. These are civil proceedings that run alongside a criminal prosecution. So bribery offences are in the sort of corruption offences package, so to speak, that's available to prosecutors in terms of dealing with bribery offending is more serious, usually. It's one of the more serious offences. And how do we know this? Usually because it involves high-profile offenders in positions of power. It usually involves a breach of trust or abuse of public office. And it often involves substantial benefits being received or advantages gained. And that's essentially because bribery conduct generally people won't engage in unless there's a serious award to be gained, a reward or gain at the end of the conduct. Bribery conduct's sophisticated, it's carefully orchestrated and it's concealed. And for those reasons, it's particularly serious. Consequences of bribery conduct is severe. It has an effect on economic growth, it discourages foreign investment and it undermines the rule of law. There are very heavy penalties that go or are available to be imposed for bribery conduct. And you'll see that. You'll know from your jurisdiction, if you look at bribery offences, the maximum period of imprisonment can range. In Australia, it usually ranges between sort of some of the offences 5 years, 7 years, and up to 10 years. Some of the money laundering offences relating to bribery can even be up to 25. And these significant lengths of imprisonment and the fines that are available to be imposed are a real indicator of how serious bribery conduct is considered. There's a couple of examples of cases that spring to mind with respect to the seriousness of bribery offences and the penalties that can be imposed. Lafessi in 2017 involved 3 individuals who pleaded guilty with respect to bribery of an Iraqi public official. And all 3 people involved, the main offender being the person who dealt with the bribe and the other 2 were the directors of the company, they all received significant penalties of imprisonment. There was a 4-year sentence of imprisonment for the person who organised the bribe, and the other 2 directors received 3 years and 4 months as head sentences. So they're quite significant sentences of imprisonment. Another case is Securrency and Note Printing Australia, which is a 2011 case which deals with 2 companies that were companies of the Reserve Bank of Australia or connected to the Reserve Bank of Australia. Those 2 companies received significant fines and a combined record pecuniary penalty order in the sum of approximately $21 million. So they're really significant outcomes or sentences that are imposed for bribery conduct. What's the interaction of bribery offences in your court? Well, there are a couple of ways that bribery offences can interact with your court. One is that there can be court staff or judicial officers engaging in bribery conduct. And the way that you deal with those will often be important. The way that you report that type of conduct and the people that you report it to are things that need to be considered. And it's often something that needs to be brought to light because that sort of bribery conduct doesn't come up unless somebody steps in and essentially reports it. And that's something that can be dealt with using your internal protocols on how to deal with those types of issues. It might be to do with your code of conducts that you may have in your courts. And it's really important to be aware of who you need to go to should such conduct be identified. The other way that bribery might interact with your court is managing bribery prosecutions. And how you do that is really important because these cases are large and they're really difficult to deal with. They can be complex and they're sophisticated and they require a lot of court resources. Some of the key things that come to mind or key features of bribery and corruption prosecutions are that they involve multiple offenders, have lots of high-profile people usually involved, and that means there's numerous legal representatives as well. So you've got a lot of players or a lot of people involved in your court that you need to manage, and you need to be able to ensure that they can be dealt with in an appropriate way and that you have key recordings of who they are for which who representatives are for which person, so that when you're dealing with filing and any communications from the parties, you're able to manage those situations in an efficient manner. Bribery prosecutions are complex, legal and factually. They often involve people to conduct maybe through supporting your judges significant legal research so that you're able to assist with identifying the elements of any bribery offences. And often the factual scenarios are complex, so often assisting judges with providing summaries of evidence is useful in terms of assisting with the managing of these types of matters. They're factually complex because they often involved lots of transactions over a significant period of time. They often involve concealment, so there's a lot of drawing connections between various different corporate entities or bank accounts or any kind of sort of property connections that may need to be essentially evidenced during the course of dealing with the prosecution, and you may be able to assist your judge with coming up with some summaries to make those connections so that it's easier for your judge to deal with when the matter's at trial. There's regular pretrial challenges and case management obstacles. And what I mean by that is generally these matters, you tend to find that there are lots of interlocutory applications or challenges, such as challenges to the form of the indictment, the way the elements of the offence are being addressed. It may be that there are challenges to the evidence that should be allowed to be admissible in a case. It could be that there are arguments over confidentiality and suppression of certain types of material. And these are all things that can come up in these matters, and it can cause the matters to drag on. And in terms of managing these types of matters, it's really useful to try and see if you can assist with perhaps suggesting some timetabling with your judge, working with your judge to do that so that they run in an efficient manner. In terms of other key features that come up in bribery prosecutions or in corruption prosecutions, there are often a significant number of witnesses, and there's a variety of witnesses. Usually there are overseas witnesses because bribery will often involve transactions going overseas. That might mean that you have some issues with respect to essentially organising the online giving of evidence, which may mean you need to set up the appropriate technology. It also might mean you need interpreters. It also might mean that you need to deal with some aspects of assuring that there are overseas availability and also dealing with time differences, just things like that that need to keep in the back of your mind in terms of managing those types of matters. It also might mean that you have to deal with some professional witnesses and experts and just ensuring that they're available at the times that they need to be in terms of providing their evidence to the court. There's voluminous documentary evidence in bribery and corruption cases. There's often a fair amount of banking material. So you need to just, it's really helpful if you get across how you're going to store all that material, how you're going to deal with all of that material, and essentially see if there's any kind of summaries that you might be able to provide to assist your judge. The other key factor that comes to mind with bribery offences is there's often civil and criminal proceedings on foot. You might have some asset recovery matters that are running alongside it. You just need to make sure that they're kept separate. Those matters are dealt with the evidence is collected pursuant to different powers. So you just need to make sure that those matters are filed and dealt with separately so there's no crossover. And so that's a really important factor. The other important things that come to mind and that are key in bribery type cases is there's a high level of public scrutiny. You might need to deal with lots of media and non-party requests to inspect documents. And addressing those matters can be helpful in terms of just identifying key guidelines within your court for how to deal with those types of queries. And also if they are missing, perhaps coming up with some guidelines to ensure that the court officers are dealing with any of these requests that might come up in a consistent way, and the recording of the decisions that are made with respect to any requests that have been processed. And the last thing that comes to mind is the likelihood of an imposition of a custodial sentence in these types of matters. So just being mindful that perhaps corrective services need to be contacted and available at the end of your trial, and also to ensure that any kind of key documents that are going to be relevant in a custodial sentence, maybe a pre-sentence report, whilst this might be the prosecution's responsibility, it's helpful if you're able to see that that document is there to ensure it doesn't delay matters, because obviously the key thing in any of these matters is ensuring that they run in an efficient way. What I was going to conclude with is that the key things that come to mind by way of summary in the role that you can play in terms of managing these types of larger, high-profile corruption or bribery offences is supporting your judges, and the way you can do this is through legal research, providing summaries of evidence, and drafting case management timetables just to assist your judge with ensuring that these run in a smooth manner, and reviewing where the case is up to see if you can identify any further challenges that might be coming up in along the way, and so you can try and triage any kind of issues that might come up. The other thing is managing the case in registry through the filing of documents, dealing with parties and media, and evidence storage. So just coming up with really good case management techniques to make sure that everything's stored and able to be identified, that the documents are labelled, that the e-lodgements are all clear so that everything is recorded appropriately. And then coordinating the case for trial, ensuring that witness attendance, IT issues and any overseas evidence and corrective services are all managed in such a way that they don't lead to any further delays in the matter. And the last thing is useful reporting, and that is providing feedback reviewing, capturing lessons learned, and creating new documents such as guidelines or practices to ensure that if there are any things that have come up through a large matter involving bribery or corruption, that some future guidelines or some future practices can be set up with your Chief Justice, so that on the next time that that type of prosecution arrives, you're able to address any of those challenges in a efficient way. Thank you very much.